They ran. 7 top attorneys fled in 72 hours after one Supreme Court ruling. What they found buried in that decision could destroy any lawyer who touches this case. But here's where it gets truly disturbing. These weren't junior associates looking for better opportunities. We're talking about attorneys who've defended Fortune 500 companies, former cabinet members, and billionaires. Partners at firms charging $2,000 per hour. And they all saw the same thing in that Supreme Court ruling. Something that made walking away from millions of dollars look like the smart choice. But that's not even the strangest part. Several of these attorneys had been with their client for years. They'd weathered investigations, indictments, and media firestorms. They'd stood shoulder to shoulder through every legal battle. So what changed? What was in that ruling that made loyalty suddenly worthless? To understand why these lawyers ran, we need to examine what the Supreme Court actually said. Not the headlines. Not the political spin. The actual legal language that sent shockwaves through every white shoe law firm in America. The ruling itself dealt with executive authority and trade policy. But buried in a footnote on page 47, the justices included language that legal experts are calling unprecedented. They explicitly stated that attorneys who continue to advance arguments they know to be legally frivolous may face professional consequences. Think about that for a second. The Supreme Court wasn't just ruling on the case before them. They were sending a message directly to the lawyers. And this is where it gets interesting. Bar associations in multiple states started informal inquiries within days. Not public investigations. Quiet phone calls. Requests for billing records. Conversations about professional responsibility. If this is already making you see the legal profession differently, drop a like so I know to keep breaking down these hidden dynamics. Now, what does legally frivolous actually mean? In normal circumstances, attorneys have wide latitude to make creative arguments. That's their job. But the court's language created a new standard. They essentially said that some arguments have become so thoroughly rejected that continuing to make them isn't advocacy. It's misconduct. But here's the thing nobody expected. The insurance companies moved faster than the bar associations. Within 1 week of the ruling, 3 major legal malpractice insurers sent letters to law firms across the country. The letters weren't threats. They were worse. They were policy clarifications. The insurers stated that any attorney who continues to pursue arguments explicitly deemed frivolous by the Supreme Court would not be covered for resulting malpractice claims. Let me put this in perspective. A senior partner at a major firm might carry $10 million in malpractice coverage. That's their safety net. That's what lets them take on high-profile, controversial cases. Without that coverage, one lawsuit could destroy everything they've built over 30 years. And the insurers didn't stop there. They also indicated that firms employing such attorneys might see their entire group policy reviewed. One attorney's choices could threaten coverage for hundreds of colleagues. Now you're starting to see why those resignation letters came so fast. And this leads us to a question that's been whispered in legal circles, but rarely spoken aloud. What happens when no reputable attorney will take your case? The Sixth Amendment guarantees the right to counsel. But that right doesn't guarantee counsel of your choosing. It doesn't guarantee the best. It guarantees adequate representation. Courts have consistently held that wealthy defendants don't have a constitutional right to their preferred lawyer. So if every top-tier criminal defense attorney decides the risk is too high, what then? This isn't theoretical anymore. Sources close to the defense team report that over 40 law firms were approached after the resignations. But the prosecution had one more weapon they hadn't deployed yet. 40 firms. All of them declined. Not because of the client's reputation. Not because of politics. Because their insurers told them no. Because their partners voted no. Because the math simply didn't work. The potential cost of destroyed careers outweighed any possible fee. But, everything I just told you? That's just the setup for what's really happening. The real revelation is still coming. Because this isn't just about one client, or one case anymore. The Supreme Court's language created a template, a roadmap, and prosecutors across the country are already studying it. Think about what this means. Any time a legal argument has been rejected enough times at the appellate level, it could potentially be weaponized against the attorneys making it. Election challenges, environmental regulations, corporate liability. The precedent doesn't care about political affiliation. It's a tool that can be aimed at anyone. And here's where the legal establishment is genuinely terrified. The attorneys who resigned aren't radicals. They're institutionalists. They believe in the system. They've spent careers defending it. When people like that start running for the exits, it means something fundamental has shifted. Subscribe if you want to see how this transforms the entire legal profession. The court essentially created a chilling effect. Not on free speech. On legal representation itself. And then the defense made a fatal mistake. Instead of quietly finding new counsel and regrouping, statements were made publicly criticizing the departing attorneys, calling them cowards, questioning their loyalty. What nobody expected was the response. 3 of the departed attorneys released a joint statement through their bar association. They outlined, in careful legal language, exactly why they left. And they included something devastating. They revealed that they had advised their client, in writing, that certain arguments could not ethically be pursued after the Supreme Court ruling. And their advice was rejected. The courtroom went silent when the implications became clear. That documentation exists in attorney files, protected by privilege. But here's the twist. If the client publicly accuses the attorneys of misconduct, they may waive that privilege. The very attacks meant to shame them could authorize them to reveal everything. This is the kind of legal chess that rarely gets explained to the public. But it's happening in real time. And this is where justice reveals its complexity. The attorneys who left did exactly what the legal profession demands. They provided zealous advocacy within ethical bounds. When those bounds became clear, they withdrew properly. They filed the required motions. They gave adequate notice. They did everything by the book. The system worked as designed. But the system working doesn't mean the outcome is simple. A defendant facing serious charges is now struggling to find representation. Constitutional rights hang in the balance. And attorneys who might step in are calculating risks that didn't exist 6 months ago. What happened next shocked the courtroom observers. The judge in the case took the unusual step of addressing the representation crisis directly from the bench, noting that while defendants have rights, so do officers of the court. The court indicated it would not force attorneys to potentially violate ethics rules, even in high-profile cases. This statement, more than anything else, confirmed what the resignations revealed. The legal landscape has fundamentally changed. Arguments that were aggressive, but acceptable are now potentially career-ending. So where does this leave us? The attorneys who resigned will likely face no professional consequences. They followed the rules. The defendant will find new counsel, though perhaps not the caliber previously enjoyed. The Supreme Court's ruling stands as precedent, available for future cases. But the real story isn't about one client, or one case. It's about what happens when the highest court sends a message about the limits of legal advocacy. Every law student will study this. Every bar association will adjust their guidelines. Every malpractice insurer will update their policies. And every attorney considering a controversial case will remember those 7 resignation letters. The attorneys didn't just protect themselves. They may have inadvertently protected a system that was being pushed to its limits. Whether that's justice, or something else entirely depends on where you stand. But one thing is certain. The legal profession's relationship with its most powerful clients will never be quite the same. Now you understand why 7 of the most successful attorneys in America walked away from millions. It wasn't about politics. It wasn't about the client. It was about a Supreme Court ruling that changed the rules of the game. Subscribe for more breakdowns of the legal battles that shape our world. What case should I analyze next? And tell me honestly in the comments, if you were offered $10 million to take this case knowing what you know now, would you risk your entire career?